Email. In many cases, reading someone else's email is a violation of federal law, but not always. We have an Arizona case just decided last year by the Arizona State Supreme Court that illustrates it, called Griffis versus Pinal County. Stan Griffis was the county manager, the highest ranking employee in Pinal County, hired by the Board of Supervisors to run the county, hire employees to do all the things the county does. He was accused of buying and selling things on the internet that he shouldn't have. Guns, all kinds of stuff. And apparently he was using his personal email account, but on a county computer at work. So the question before the court, when the newspapers wanted copies of his emails to find out who he was dealing with in selling this stuff illegally, the county said, no, you can't have that because it's on his personal account. How's that sound to you? Is that a fair?
Yeah.
So all you have to do, Kasia, if you want to steal, is just log out of your county account, just go on to AOL or Hotmail, and then you're in the clear.
Because then, I mean, you'd never be able to check your personal email ever at work, so.
Well, you could check your personal email at work. It just would have to be, we would hope, something that you wouldn't mind sharing with everybody else. If you were accused of a crime, they just can't look at it willy-nilly because they want to. This is obviously something bigger than that. So if throwing in the possibility that you're using that personal account to commit a crime, is that okay? Aaron?
Well, I just think if he used the county computer, he was doing it on public resources. It's one thing if he goes home and does that, but he's probably on the clock, doing it during and on.
Likely so, sitting in there during work hours. What if he came in on Saturday though, and did this very same thing on the county computer, used his personal account?
Still taxpayer property, technically, so.
What if you go to a library and use the library computers?
Well, as long as nobody is checking it at the library, I guess you might get away with it, right? See, Mr. Griffis was accused of this stuff not because they found him out on his computer. They figured out what he was doing and worked their way back to his computer, and so the media filed a motion to get access, fill out a request to get access to the public records that they believed were Mr. Griffis' emails, even though they were on his personal account. They claimed, we want those records because the server will have it. Hope you know that. You use your private account on an ASU server, it's kind of there. And so they thought that they were entitled to it. The county said, no, you're not. Certainly Mr. Griffis' attorney said, no, you're not. So this particular matter, a side matter to the case against Mr. Griffis in the criminal court, went to the Supreme Court to decide. And they ruled that a personal email written or received on government workplace computers is not a public record unless the judge says it is after inspecting it in his chambers. Something, the Latin term in camera. That's pronounced like camera, but it's camera. Using your eyes to inspect, that's where the word camera comes from, another Latin word. In camera, meaning in chambers. Back there, the judge will look at the emails and decide whether or not they have a certain amount of public interest, and then the judge will release them to the public and the media. But what you have to do is file a motion asking the judge to do that, which means hiring a lawyer, which means costing money. So the press saw this as a partial victory